Hello, my name is Andrew Flushy, and I'm your Virginia traffic attorney. Did you know that if you're charged with refusal on private property, that you have a solid defense to that case? A refusal charge in Virginia requires that you were operating the vehicle on public highway. Now, a highway doesn't necessarily mean the interstate. It means any road or even just area for driving that's open to the public. It's a very broad scenario of roads or parking lots even that can be a highway. However, it does have to be public. It cannot be private property for a refusal charge. So what happens in some scenarios is, let's say you're in a parking lot for like an apartment complex, and maybe there's signs up saying, no, only residents allowed, no soliciting, no trespassing. Well, that makes it where that area is more like a private property area where not everyone's welcome. The general public can't just drive through there. It's only for residents, and only for specific reasons can guests come. And so if you're in that area and the Commonwealth can't prove that you were operating on a public thoroughfare, a public highway, then we have a solid defense to a refusal charge. And in that scenario, that turns a DUI case a little more in our favor if you refused. Typically for a DUI, a lot of people end up having to plead guilty to a DUI to try to get a restricted license right away. But if we have a solid legal defense to a refusal, we might can have the Commonwealth drop the refusal charge at the outset, and then we just have a DUI to fight. And if there's no breath certificate, that puts us on a little better ground, of course, to fight a DUI. So if you were charged with refusal and you think it may be private property that you were on, contact me today or request my free book so we can talk about your case.